case of Nnamdi Kanu versus Federal Government of Nigeria, the defendant was charged with treason and allied offences before the Federal High Court. During the pendency of the case, the defendant jumped bail and fled to the United Kingdom while on a trip to Kenya last year. The defendant was abducted and brought to Abuja by Nigerian security operatives. Without considering the legal implication of the rendition, the Attorney General of the Federation and Minister of Justice, Mr. Abubakar Malami SAN, announced that the trial of Mr. Kanu would soon commence. Thereafter, the charge was amended while the defendant's application for bail was dismissed. However, the preliminary objection filed by the defense against the 15-count charge partly succeeded as 8 counts was dismissed by the trial judge Binta Yanko J. Dissatisfied with the ruling of the Federal High Court, the defendants approached the Court of Appeal for redress. In an epochal judgment delivered a fortnight ago, the 3-judge panel of the Court of Appeals, led by Justice Jumai Hanatu, said it was satisfied that the federal government flagrantly violated the law when it forcefully rendered Kanu from Kenya to the country for the continuation of his trial. It held that such extraordinary rendition without adherence to due process of the law was a gross violation of all international conventions, protocols and guidelines that Nigeria is signatory to, as well as a breach of the appellant's fundamental human rights. The court noted that Nigeria is a signatory to OAU Convention, which it ratified on April 28, 2022, as well as the Charter of Human and People's Rights, which it said prescribed how a wanted person could be transferred from one country to the other. It held that any extradition request must be in writing, with a statement indicating offences which a person is wanted. You see that Malami has deceived Buhari and the rest of them. The appellate court held that Nigeria government's action tainted the entire proceeding it initiated against Kanu and amounted to an abuse of criminal prosecution in general. Having found out that the federal government had engaged in serious abuse of power, their lordships said that the courts will never shy away from calling the executive to order when it tilts towards executive recklessness. Consequently, they struck out the remaining 7 counts pending at the Federal High Court, discharged the appellants and ordered Mr. Kanu's immediate release from the custody of the state. The federal government has filed an appeal against the decision of the Court of Appeal and a motion for stay of execution pending the determination of the appeal, while the grounds of appeal have not attempted to justify the refusal of the federal government to comply with the provisions of the African Union Convention on Extradition and the African Charter of Human Rights People's Rights. The application for stay constitutes a gross abuse of court process. In the case of Nigerian Army versus Buhari 1992, the Court of Appeal dismissed the motion to stay of execution of the judgment of the law of the Lagos High Court for the release of the appellants. In justifying the ruling of the Court of Appeal, Cargo JCA held that the refusal of the application was not cause any injury or will not cause any injury on the applicant, but if the application is granted, the respondent will continue to suffer personally in detention after the court has declared her detention unlawful ab initio. Based on the dismissal of the application for stay of execution, the main military junta released the respondents from further custody. No doubt a defendant may be discharged by a criminal court on the grounds that the charge against him or her has not been of substance or due to an incurable defect in the charge. The case is struck out while the defendant is discharged and ordered to be released. The state may rearrest and rearraign the defendant if there is fresh evidence or the defect has been cured. But in certain cases, the defect cannot be cured. For instance, Erin Oka was arraigned on a 62-count charge, We challenge the competence of 59 of the counts due to the fact that the offences were allegedly committed in Bayelsa while he was charged in Jos, Plateau State. As the state has no answer to the objection, the counts were withdrawn and struck out by the trial court. We also challenged the jurisdiction of the court to try the remaining 3 counts on treason and treasonable felony, as they were not filed within the mandatory period of 3 years permitted by law. At that junction, the Yaradua regime opted for political resolution of the case. The state filed a no prosequi application, which led to the termination of the case. Similar cases pending against other militants were discounted while the state adopted the amnesty program. That was how the federal government restored law and order in the Niger Delta region. In the instant case, the claim of the federal government that there are some pending charges against Mr. Kanu in the Federal High Court is a contemptuous mockery of the Court of Appeal, which has struck the remaining 7-count charge. Any new charge anchored on Kanu'S illegal abduction from Kenya is bound to fade. To that extent, the order of discharge is akin to an acquitter. The federal government should take advantage of the intervention of the court to adopt a political solution in the resolution of the case. Since the federal government is currently engaged in negotiations with terrorist groups, it should not hesitate to enter into negotiation with the Nnamdi Kanu and his group without any further delay. And that is exactly what they don't want to do. But when it comes to this Boko Haram, they are very swift. Oh yes, some people have repented. When they do repent, nobody sees them. When they are surrendering, after all, if they really repented, they are supposed to be surrendering their ammunitions, but we have not seen all of those. But what we always know is that they always spend money on them. They will tell us that they've repented. How? They will just write some placard, some things on the placard, and they will just display it, and that's what we've been saying. But for them to sit down, because that in it that alone shows that there's nothing like anybody repenting, but they're just trying to do wuru wuru. Because if it is easy that they really dialogue or negotiated with the terrorists, I see no reason why it would be difficult for them to do the same with Nnamdi Kanu. But as it stands now, Malami has deceived Buhari enough, because as it stands now, it shows that Malami knows nothing. See, they've even goofed. Going to Kenya to bring this man, they've goofed already. They goofed big time. And that is why there's nothing they will do that will make meaning. And they are just trying to buy time just to shift the evil day. And they don't want to come out and say, oh, we want to release this man, so that it will appear that they have made mistakes. And now, from all indications, a lot of people have been speaking to Buhari that, hey, you know, this man has done damage, but they just have to look for a way to make sure that they try to cover up their mistakes. But they ought to have known now that the lawyers are not people now, because they will just have to look at how did Nnamdi Kanu got to Kenya, with which visa, with which passport. That alone again, the goofed. So guys, let's hear your opinion and have your take on this.